My Lords, just picking up on 2 points from this morning. In terms of the statutory guidance, although for the reasons I've given we submit it's not relevant to any challenge to the decision in question, we would say in any event there is nothing about the decision-making process or decision that's inconsistent with the statutory guidance. And then secondly, dealing with, I think, my Lord Hughes' question about whether the terminology in the document comes from anywhere in particular. It's certainly not cut and paste from anything, but it's right to say that there was, at the material time, something called a quality assurance framework, and section MP8 of that is the Chief Officer's guidance. And that, I'm afraid I don't have a copy, but I can obviously provide copies to the court, but that poses the question, is the information sufficiently credible to justify disclosure? And it goes on to say, it refers to that being organisations such as Liberty argue that a test of balance of probability should be used. Case law asks that you consider whether there are any circumstances that lead you to consider that it's unlikely that the information is true or the information is so without substance as to make it unlikely to be true. So the so without substance is drawn from the non-statutory standard guidance that was in place at the time.
Thank you.
If I can then just deal with my learned friend's specific criticisms of the respondent's decision-making process. Firstly, in terms of the argument that the police should have obtained a full transcript before assessing the reliability, that's based upon the Tameside duty of reasonable inquiry, the general public law duty. That, however, is a duty that's subject to challenge only on a rationality basis. There is no basis for characterising a decision by the police not to obtain a full trial transcript as irrational. The police had, of course, the very full summing up. I haven't taken the court to the summing up, but if I can give you the reference, in the it's MS page 350, and the police also had the forensic evidence, which begins on MS 338. I'm sorry, I should just give you the appendix pagination as well. The forensic evidence starts on appendix page 208, and the summing up is appendix page 220. I won't take the court's time up by going through it, but I commend it to the court as in terms of reading the summing up. It gave a very full account of the evidence that had been heard and the issues that had been raised in the course of the trial. So that's the first way in which I respond to that criticism. Secondly, this point about not obtaining a transcript was never raised in the appellant's judicial review grounds. It was never a pleaded part of the case. It was raised before His Honour Judge Rayner and at the hearing, and rightly rejected in my submission for the reasons given at MS 188, appendix page 58. It wasn't then raised in the skeleton before the Court of Appeal, but has been resurrected now. Thirdly, in terms of the transcript, the appellant's not identified any information which he says the police would or even might have obtained from the transcript that wasn't available from the summing up. And if my learned friend's argument is that the court itself, this court, or the Court of Appeal, should be undertaking its own assessment of proportionality, the appellant has never sought to place that material before the court. And so, for those reasons, in our respectful submission, there is nothing in the complaint that there should have been a full transcript of the evidence obtained. And it's asserted by my learned friend effectively as some kind of hard and fast rule that it should be obtained, with no principled basis upon which to support such an argument. Second criticism, the inferences to draw from the acquittal. I've largely dealt with this in my submissions already. In our submission, there's no error by the Chief Constable nor by the judge, and the reference in his judgment is MS 188, or paragraph 40E, in acknowledging that the acquittal doesn't prove innocence, but that he couldn't be proved guilty beyond all reasonable doubt. And as we set out in the written case, neither the police nor the court can know or ever know the juror's reasoning process. and the decision correctly identified the only reasonable inference that could be drawn. And it didn't follow from the fact of acquittal that the allegations themselves had to be regarded as unreliable, lacking in substance, implausible or unlikely to be true. My learned friend's written arguments also include a complaint that the respondent failed to consider the reliability of the allegations. That, in my respectful submission, is plainly wrong when one looks at the decision-making documentation. All the particular points which had been advanced were considered, and the possibility that the allegations might not be true was recognised, but the police correctly noted the allegations that might not be true can nonetheless be disclosed. And the conclusion, in my respectful submission, that the information was not lacking in substance, that it was reasonable to believe it might be true, was not only a perfectly proper conclusion for both the police to draw and the court to endorse, but the correct conclusion. One couldn't possibly, on the material, reach any other conclusion on the facts of this case. The next complaint my learned friend advances is that the decision was not open-minded and lacked balance. That is not a fair reading of the decision as a whole. My learned friend complains about the use of the word victim. As my learned friend will no doubt recall, he himself used that phrase repeatedly in his submissions before the Court of Appeal. Read as a whole, it's quite clear that the respondent was not assuming, by the use of that phrase, that the allegations were true, and was not approaching the issue with a lack of balance. I've dealt with the CPS decision in relation to charging as a starting point. In terms of the complaint that the police's decision-making process identifies the points that had been or could have been raised by the appellant and then answers them and rejects them, that can't possibly lead to an accusation that there was any lack of balance or any bias or absence of an open mind. The police decision maker was there doing her job, looking at all the relevant points and setting out what she thought of them. So there's nothing in that point. I've dealt with, I think, paragraph 420 of my learned friend's written case, the issue about the need to prove balance of probabilities. At paragraph 421 of his written case, let's just invite the court to turn to it. It's MS, page 77, page 22 of the written case, using its internal pagination. It's suggested that the importance of protecting the rights of the acquitted should bear some weight in the proportionality exercise. Now, whilst we entirely accept that the fact of acquittal and the nature and reasons for the acquittal may be relevant to the assessment of reliability, and that the impact upon the individual must be considered as part of the balancing exercise, it is unclear to us how it can be said that the fact of acquittal itself bears any particular weight in the decision-making process in the sense suggested in paragraph 421. And it does appear that that is an attempt, in part at least, to reintroduce the Article 6.2 arguments by the back door. And in terms of paragraph 422 of my learned friend's written case, the suggestion that there's a matter that should carry particular weight is the risk of stigmatisation where an unconvicted person is treated in the same way as a convicted person. Well, it's simply wrong to characterise the decision to disclose as treating the appellant in the same way as a convicted person.
But it has that consequence, doesn't it?
Well, no, because a convicted person would have their convictions disclosed through the first part of section 113B, subsection 3. And those convictions would record, obviously, the fact of conviction with the inevitable inference of guilt. In terms of a person who's been acquitted, they are, in many respects, in no different position from the person who has not been charged, but nonetheless, there are allegations, soft intelligence, complaints, etc., which is the very purpose of section 113B4. The fact that they have, in the case of someone in the appellant's position, there was sufficient evidence to justify a charge, but there was not a conviction, doesn't mean that they fall to be treated in a in some sense, a more lenient way than a person in respect of whom no question of a criminal charge was ever raised, or the case never got that far, but nonetheless allegations against them are included. Section 113B4 will always be dealing with the unconvicted. And so it's wrong to suggest that...
All that I'm suggesting is that stigmatisation is the inevitable consequence of the revelation that one has been charged with a serious offence of rape.
Well, there will be inevitably stigmatisation from any allegation that's regarded as sufficiently serious to merit disclosure for the purposes of Section 113B4.
Yeah.
Can
Right.
you help me there? You said it's like someone who's anyone who hasn't even been charged. But surely if it's soft intelligence, it will tell you the nature of the intelligence, will it? I mean, what would be disclosed?
Well, there is a very wide range of material that may be disclosed. So it may be the number of the cases deal with allegations against nurses or care home workers or those working with children that have been made by those caring for them, which have never got anywhere near.
But what you'll say is someone made an allegation about this woman 5 years ago.
Yes. Someone alleged that this person assaulted.
I mean, the problem I'm getting, it seems to be that the information, all you get is the information that this person has been charged and acquitted. And I just don't know what you're meant to make of that, because it doesn't tell you anything about whether he was rightly charged or wrongly charged, or rightly acquitted or wrongly.
No, but that's the nature of the scheme. So where there is, for example, a complaint that's been made or an allegation that's been made that doesn't go through any form of criminal process, again, what you might see is care home residents alleged that
But I mean, the
individual...
complaint he seems to be making in his letters was not that there'd been disclosure, but there'd been disclosure without giving any information about all the inconsistencies and so on. I can see that it's rather difficult for the police constable to do that.
Yes. Well, I think the complaint that was being made about the inconsistencies was not that those inconsistencies should have been referred to expressly in the disclosure text, but that those inconsistencies meant there should have been no disclosure at all.
Yes, I see.
And what the police have sought to do in terms of the disclosure text is to explain the nature of the allegation in the same way as they would if there hadn't been a criminal process but there had been a complaint, and the response to it, which was denial, and the fact of acquittal, which is included in terms of fairness to the individual.
There was a good deal more in this certificate than just he was accused of rape and acquitted, wasn't there? There was the detail of how it's all set out in the judge's judgment at paragraph 5, but it's a summary of the complaint against him and what his response was.
Yes, precisely. And so that, I think, deals with my learned friend's criticisms of or specific criticisms of the respondent's decision. In terms of his criticisms of the judge's decision, again, without wishing to take an excess of pleading points, I asked the court just to note and perhaps look at appropriate moments that the pleaded case that the judge was dealing with was very briefly set out. It's paragraph 4.8 of my learned friend's grounds. Forgive me, I haven't noted down the MS reference. I'll just get that. It's appendix page 151, MS 281. The majority of the arguments before the judge were, in fact, in relation to Article 6.2, which is not before this court, and the retention of data, which was withdrawn before the Court of Appeal. And so when one considers the judge's approach, it is only fair to consider what the case was that the judge was being asked to consider. It's right, of course, that my learned friend elaborated upon those submissions in his oral argument, and that's recorded in the judge's judgment. But in terms of the judgment itself, MS 187, my learned friend is referred to, it's appendix page 57. My learned friend is referred to various sub-paragraphs in paragraph 40, but the starting point for the purposes of the Article 8 argument is paragraph 39 on MS 187. It says, for reasons which I shall state, I am satisfied that the interference with the claimant's rights was justified and that the disclosure in that certificate was reasonable, proportionate and no more than necessary to secure the objective. That is unequivocally the judge performing the exercise that the case law says the first instance judge must perform, which is undertaking reaching his own decision on proportionality. And then, again, in terms of what's then set out in paragraph 40 onwards, he identifies clearly where he says there were flaws in the decision-making process by the police. He doesn't ignore those or fail to take them into account, but sets out in 48 his view that the material was carefully considered and, in my judgment, the comments on the forensic and medical evidence, etc., were fair. And then he again sets out in terms of his own decision, complainant's evidence derived some support from medical evidence in distress, and he points out that there's no criticism about the comments of the respondent regarding the lack of indication of a motive to make a false allegation. So again, he is quite clearly there, correctly performing the role of the first instance judge. At B on page 58, MS 188, it's absolutely right to note that he uses the word reasonable in relation to the acquiring of a transcript, but that's perfectly right. There's nothing in Article 8 that requires a transcript to be obtained. That doesn't go to proportionality, that's a rationality issue, and as I say, was never in fact pleaded. And then he sets out his own view in any event. I consider it was sufficient that they had a transcript of the summing up. Subparagraph C again sets out both what the police did, fact of acquittal was recognised, and then his own view. In my view, it was right to comment that nothing could be assumed from the fact of acquittal, etc. And then in D, he identifies, the second flaw, but then says, I'm quite satisfied the Chief Constable was fully entitled to conclude. In my judgment, that's a sufficient basis. And then he goes on to consider the issue of proportionality. I'll skip over what he says about the procedure at E. At F, he talks about the impact, and then he looks both at the Chief Constable's decision-making, says the Chief Constable was justified in the conclusion that he reached, and then sets out his own view. I am satisfied the disclosure was no more than necessary to meet the pressing social need and the balance was struck in the right place. So it's absolutely clear that he both looked at, as he should, the primary decision maker, accorded that appropriate weight, noting as he did, indeed finding as he did, that there were two flaws in that assessment, but not any other flaws, and agreeing with the approach taken by the decision maker in relation to the remainder of the points. And then he set out his own conclusion on the issue of proportionality. So the criticisms that are made by my learned friend of the judge in paragraph 411 of his written case, in my respectful submission, are without foundation. So by way of conclusion on the issue of proportionality, we've set out in the written case this court's, I think, most recent articulation of proportionality in the Bank Mellet case. I don't propose to take the court to that. Of the four elements of proportionality, we are really only here concerned with the fourth, whether the impact of the interference was disproportionate to the likely benefit of the impugned measure. And the submissions I make in that regard are as follows. The purpose of section 113 4 is the protection of the vulnerable from harm. That requires, the section 113 B4 requires an evaluation to be made by the Chief Constable. And the evaluation that was made here was in the context of an allegation of rape by a taxi driver of a 17-year-old drunk passenger in the context of his application for an ECRC for the purpose of continuing to work or obtaining work as a taxi driver. So it could not be more relevant. It was plainly material that was reasonably reliable, not inherently unreliable as some of the other cases have been, not unlikely to be true or probably not true, but reasonably reliable. We accept entirely it's a difficult and sensitive decision that the primary decision maker has to take. But here, the right factors were identified, the gravity of the material. This was amongst the most serious kind of allegation. If true, it would indicate high risk. Consideration then of reliability, which I've addressed. That's precisely the exercise undertaken in the form that we've looked at. Currency, this was recent at the time. Impact upon disclosure, and then a conscientious balance of those factors. It is our submission that the decision of the respondent to include that material was proportionate, that the judge neither erred in principle nor was wrong, in his conclusion that it was proportionate. And that if, contrary to the arguments that fall to be considered in relation to my learned friend's submissions on the role of the appellate court, if we're wrong and the Secretary of State is wrong in that regard, and it's for each court to undertake its own assessment of proportionality, then we submit, for the reasons I've summarised and are set out in more detail in the written case, that the correct outcome is that this is a proportionate decision to disclose, or was at the time in 2012. Obviously matters, we're now 5.5 years later. Can I move on then to the procedural challenge?
Oh, can I just ask you on that
Yes.
one before you do? While it's clear from your submissions that you would say that it doesn't affect the outcome of the decisions made at any stage here, do you accept that the Queen ex parte A doesn't accurately, doesn't fully reflect what was said by this court in Re B, insofar as it only mentioned error of principle and not reaching a wrong conclusion?
Yes, I mean, whether that was just being used as a form of shorthand by the court or not, I don't know. But we certainly accept that indeed it's the principal basis for the Court of Appeal's intervention in a case and allowing appeal is if the decision is wrong.
Yeah.
The real question is what's meant by wrong, and I will come on to that after I've dealt with procedural fairness.
And if that criticism can be made of A, it can also be made of a Court of Appeal's judgment in the present case.
Well, not in my submission. Again,
Are you going to come on to that?
Yeah, I'll come on to that, but it's really that,
Well,
that
keep in
last
mind that
part.
you have now 8 minutes left.
Yes. I mean, I don't know whether the court will be indulgent in affording any more time in view of the fact that Mr. Suddy took less.
Very little indulgence, I'm afraid.
Well, let me deal with the procedural challenge in the knowledge, at least, that the third issue can be dealt with by Mr. Moffat. In terms of what's required in an individual case, the general points are these. The case law does not establish that there's a duty in all cases, or all cases involving acquittal, to seek representations from or consult with the applicant. What the case law establishes, it's that it's impossible to be prescriptive as to when such a duty will arise, and each case turns on its own facts. The ultimate question in terms of Article 8 is, and we've set out the material in the written case, so I won't take you to the case law, is has the individual been involved in the decision-making process seen as a whole to a degree sufficient to provide them with the requisite protection of their interests? And that's a very familiar formulation. It's derived from Strasbourg, and I'll just give you one reference to it. It's Blecic and Croatia, Authorities Bundle 5, tab 48, paragraph 68, MS 1943. Can I, in view of the limitations of time, just give you the references in Re L to the issue about procedural fairness? Because the court dealt with this in terms in the various judgments. It's Lord Neuberger, paragraph 82, Authorities Bundle 1, tab 5, MS 537, where he says some, indeed many cases, that you should contact the applicant, but impossible to be prescriptive as to when. At paragraph 84, again, Lord Neuberger, MS 538, where he says he's far from suggesting that the duty would arise in every case. It's then Lord Hope, at paragraph 46 of the judgment, MS 528, where he says it's only in cases of doubt, and he sets out what he means by that, that you need to give an opportunity to make representations, not necessary in every case. And then Lord Brown, paragraph 63, MS 533, who refers to in any borderline case, that opportunity being given. And to similar effect, again, I'll just give you the references, is the Court of Appeal's judgment in C in the Secretary of State for Justice. That's Authorities Bundle 4, tab 27, MS 1411, where Lord Justice Toulson said it was ultimately a fact-specific question applying the general guidance laid down in L. And I invite the court's attention when the court is considering this matter to paragraph 13 on page MS 1411, where the court said this, Lord Justice Toulson, with whom the Master of the Rolls and Lord Justice Wilson agreed: we expect the individual to set out the representations they would make and not just come to court and complain that they were not afforded the opportunity to make representations. And then just dealing with the facts of this case viewed from the prism of the procedural fairness challenge, the first ECRC was March 2011. And the page for that, you don't need to turn it up, is MS 360, Appendix 230 to 231. That wasn't challenged, but the appellant made representations in April 2011 to the CRB, that's Appendix 237, MS 367. And the points he made was, well, I haven't been convicted, this is prejudicial, the jury must have rejected her account. Those representations were considered in the context of the first ECRC in May 2011 by Inspector Kynaston, MS 369, Appendix 239. The appellant then wrote to the IGU, the Information Governance Unit, on the 2nd of June, setting out his concerns about the disclosure. And I will just ask you to look at this, please. It's at the very back of the appendix. It's MS 384, page 254. This is his letter to the police, June 2011. Again, it refers to what he says, he maintained his innocence, I know I'm innocent. He refers to there being many inconsistencies in the female's account and someone else's DNA on her underwear. So those are the key points that he makes in that letter. Those representations were considered by Mrs. Wilson, still in the context of the complaint about the first ECRC, on the 19th and 20th of March 2012. It's Appendix 240 to 244, MS 370 to 373. And she gave express consideration to that. It's actually an identical term to the subsequent point made only a few days later, unsurprisingly. She gave express reference to what he'd there said. In the meantime, he'd submitted the second application for the ECRC in connection with the taxi licence, and that's what I've taken the court through at MS 324 to 336, Appendix 192 to 206, with express consideration being given to the matters that have been raised by the appellant. So the second decision was taken having regard to and in light of the representations that had been made by the appellant. And so those were considered before the decision was taken. And so when one goes back to the principles in L, this was a case in which, unlike many of the others, it was known what the appellant's position was in relation to the substance. He denied it. He had an opportunity to answer the allegation in the context of the criminal trial. He'd rebutted it. His position in relation to the rape allegations clearly set out in the police documentation, and his representations were expressly taken into account during the decision-making in respect to the second ECRC. Add to that, this wasn't a borderline case in terms of relevance, no doubt about relevance. It wasn't a case where the information was historical or vague, it's recent and specific. And it was known that what the impact of disclosure might be on the ability to gain employment in the chosen occupation. That was expressly taken into account. And so it can't possibly be said in our submission that the decision-making process viewed as a whole failed to afford him the appropriate measure of involvement in the decision. The second point in relation to procedural fairness is that the appellant has never identified, either before His Honour Judge Rayner or before the Court of Appeal, any new or additional points he would have made if he'd been given a further opportunity in March 2012 to do so. The issue was never raised in the pre-action protocol correspondence. It was raised in the judicial review grounds in very bland terms. The reference to that is Appendix 150 MS 280, paragraph 4.2.2. It was expressly addressed by His Honour Judge Rayner in his judgment, Appendix 59 MS 189, paragraph 40E, and he made the point that the appellant hadn't set out anything that he would have said. In the Court of Appeal, in his skeleton argument to the Court of Appeal, again, the appellant merely just generally asserted, well, a wide range of other matters might need to be considered, but failed to identify what those were. And again, the Court of Appeal made exactly the same point as his Honour Judge Rayner, at paragraph 66 of the Court of Appeal's judgment, Appendix 31, MS 161. And in response to a question from the court to that effect, all that's been said is, well, there might be matters relating to employment. But in terms of that, the police weren't under any illusion here. It was known and recognised that inclusion of this material in the certificate might well, and one couldn't say with certainty, but might well prevent him from working in his chosen employment. And so it's perhaps also relevant to note, just in relation to the procedural fairness, in light of the passage of time, the ECRC under challenge is now completely out of date. The appellant has made a number of further applications for ECRCs which have been placed on hold or withdrawn at his request. But in the course of that, in accordance with the new statutory guidance, he has been invited to make representations and has done so. And there is, I think, one outstanding application which is on hold at his request pending the outcome of this hearing. That's not yet reached the representation stage, but in accordance with the statutory guidance, it's likely that he will be offered the opportunity to make representations. So any debate about what procedure was or wasn't in operation in March 2012 is now academic and sterile, in light in particular of the changes that have been made to the Act, not just the statutory guidance and what it says about consultation, but the independent monitor scheme set out in my learned friend's, Mr Moffat's written case, that there is now effectively a right of appeal to the independent monitor. And so there are now procedural safeguards that were not in existence at the time of the decision under challenge. That's obviously not relevant to the question of whether the respondent acted unfairly, but they have the consequence that in relation to any current or future applications, the appellant will have the benefit of those additional safeguards that have been conferred by amendments to the statute. So, my lords, I think that deals adequately with the procedural fairness argument. My learned friend's submissions in our case effectively ignore the fact that the police had his comments and representations before taking the second decision and paid express reference to it. My lords, might I just perhaps take 5 minutes to deal with the third point and then leave it to my learned friend Mr Moffat to develop it? A short 5 minutes. Certainly. Well, my lords no doubt have the position in the written cases. Whatever Lord Neuberger's 7 categories in Re B do or do not encompass, we entirely accept that the appellate court may intervene either where there's a serious error of principle or where the decision is wrong. The key question is what is meant by wrong. Where we part company with my learned friend's submissions and with my Lord Kerr's dissenting judgment in Re B is to suggest that that requires, in the context of a proportionality challenge, that the appellate court undertakes the same assessment. And the reason why we say that's wrong is that the assessment of proportionality is not a hard-edged question which permits of only one answer. It's an evaluative judgment. The more a value judgment is the way in which the courts have often termed it, with a number of factors that fall to be taken into account and questions of weight to be given to those factors. And those are not scientific questions which permit of only one answer. There is not only one quantification of weight to be given to any particular factor in the balancing exercise. It is an issue upon which decision makers can lawfully disagree and reach different decisions. And there is ample authority to that effect. I'll just give you the references and I won't take you to any of them. Mr Moffat may do so. We have it in particular in Southend-on-Sea and Armore in the context of statutory appeals, Authorities Bundle 4, tab 37, MS 1635, which talks about proportionality not being a bright line test but a value judgment. To the similar effect, Wilson and First County Trust, Authorities Bundle 2, tab 13, MS 772, paragraph 2. and Mersey Care Trust and Ackroyd, Authorities Bundle 2, tab 20, MS 989, paragraphs 33 to 36, and MS 1002 to 1003.
Yes.
Again, which expressly contemplates that proportionality involves a value judgment on which reasonable people could reach different decisions. And then that very issue is expressly addressed.
We know all that. We know that it's an evaluative judgment. The question is, why is there an evaluative judgment which is left to the trial judge and not to the Court of Appeal?
Well,
quite different point.
Well, my Lord, because the alternative is that at each and every stage of the appellate process, the court performs an identical function.
Yeah, I mean, that's a policy point which the majority appear to have taken up in B, so that's your,
which is the point in
that's your case. Yeah.
which is the point in B.
But how do you decide that the judge was wrong unless you make a decision as to what was right?
Well, the judge that potentially presupposes that there isn't. We say there may be individual cases where there is only one right or wrong answer, and that's where there is true scope for wrong. But when the Court of Appeal ordinarily concludes that a first instance judge is wrong, it is usually because they have gone wrong somewhere in their reasoning process. And that's where you get the concept of flaws or errors of principle.
But the problem with that argument is that it fails to address the point that Lord Neuberger expressed as an alternative to an error of principle, a decision that the lower court was wrong.
Well, a decision that displays no error of principle but is wrong will be wrong where that wasn't a decision that was open to the court to make on the material before.
That's not what he said.
It is what he says in the first part of that paragraph, not what he says in the second.
Not what he says in the
And the
second.
problem is a crucial paragraph, with great respect, seems to me to be saying two different things.
Yes, well
You know, you may have submissions that really help us and decide what to do with it.
yes, I understand that. Might I just give the courts one additional reference in the authorities, which is the P.E. Peru case, which is Authorities Bundle 4, tab 28. Paragraphs 9 to 11 at MS 1418 to 9 and 27 to 8 at MS 1425 to 6. That's the Court of Appeal which had granted permission to appeal expressly on the basis of considering that issue in the context there of an immigration case. And there Lord Justice Sedley deals with my learned friend's argument really about the European Court of Human Rights and mirroring the European Court of Human Rights, and explains that the European Court is in a different and unique position because it's both a court of first instance and
Yeah,
last
but we're not
resort.
dealing with that. We're dealing with a perfectly domestic question, as how a British, a UK, English and Welsh court of appeal should deal with this particular problem.
Well, my Lord, we say, building upon those parts of Lord Neuberger's judgment and the judgments of Lord Wilson and the which deal with this issue, it is clear in those judgments that the majority were not saying that the court, the appellate court, in proportionality cases, must always undertake the same exercise again, which is the logic of my learned friend's position. Lord Neuberger says, indeed, in our assessment, the very opposite of that.
Well, I think perhaps we've probably exhausted.
Well, I've certainly taken up longer than 5 minutes, my lords. So in conclusion, we say, just applying what we say are the correct principles, His Honour Judge Rayner neither erred in principle, and the appeal against his judgment was made solely on the basis of his decision being flawed by various errors, when one looks at the grounds of appeal and skeleton argument. Nor was it wrong, for reasons I've given and won't repeat. Likewise, insofar as the Court of Appeal is concerned, they were right both to conclude that there was no error of principle on the part of His Honour Judge Rayner, and they expressly set out in the final sentence of paragraph 76, the judgment of Lord Justice McComb, they saw no reason to disagree with his assessment of proportionality, i.e. it was not wrong. But if, contrary to all that, it's for this court to assess, then, as I say, for the reasons we've given and have set out in writing and are set out in the original decision, disclosure was proportionate.
Thank you very much. Ms Dobson, do you want to crave yet further indulgence?
Wise.
Yeah, Mr Moffat.
Well, Lord, I'll crave a little bit of indulgence, if I may. What I propose to do, if it's convenient to the court, is to deal with two matters in my submissions. First of all, to touch on the point about the role of the appeal courts, the points that my friend has just been making submissions on. And secondly, just to touch on the Secretary of State's guidance and to say a little bit about that. As the court will have seen from our written case, the Secretary of State doesn't propose to make any submissions on the facts of this particular case. I do, however, adopt what my learned friend Ms Richards has said about the general principles under Article 8 and how they apply in these sorts of cases in general. Can I then turn to my first point, which relates to the role of the appellate court? Listening to my learned friend Mr Southey's submissions, it seems to come down now to the question of what Lord Neuberger meant when he said that the question for the appeal court was whether there was an error of principle, or more particularly, whether the trial judge had got it wrong. Our submission in a nutshell, which chimes with what Ms Richards was saying, is essentially the approach to be adopted by an appeal court in these sorts of cases is no different from the approach that an appellate court conventionally adopts in any case where there is an appeal against an evaluative judgment by a trial judge at first instance. There is nothing in the convention.
Where do you find the best statement of what?
That's in Re B itself.
No, somewhat other than Re B. Re B is what
well, I
I
was
have
going to say,
problems
Re B
with. But this is, I mean, it's something that's been going on
wants to go.
ever since I've, been around courts of appeal are having to deal with evaluative judgments of first court. There must be a very straightforward statement in some authority.
Well, look, Re B deals with it because Re B deals with it in a different context, apart from the human rights context, which is the evaluative judgment as to whether the threshold for making a care order in a children case is so it's dealt with in two contexts.
Well,
and in that,
of course, it's complicated by the fact that that is a case where the judges heard days of conflicting evidence.
indeed, it was some 20 days.
Yes, I mean, what we want is a nice straightforward statement of what the court should do, where you've got the first court making an evaluative judgment without having heard any evidence, and therefore material before the appeal court is precisely the same as was before the trial judge.
Well, Lord, I was going to go to Re B. I will come to Re B in due course. I'm not sure we have anything, certainly from this court or indeed even from the Court of Appeal,
There must be.
that directly deals with it.
Ever since the dawn of the common law, people were struggling with this problem. I simply don't believe there's no.
Sorry, I meant in the authorities before the court, but it may be that Mr Knight will be able to dig something up.
I don't worry, we can find, I'm sure our JAs can find it.
But we'll look at that, my Lord, and hopefully have an answer for you before the end of my submissions. But, my Lord, that is the essence of our submission. Mr Southey's submission started from 2 points. He set out 2 propositions at the start of his submissions, which he said led to the conclusion that he said this court could come. First of all, he said that proportionality was a hard-edged question of law. And secondly, he said that the domestic courts were required to reach the same outcome that the Strasbourg court would reach if the case went on to that stage. Both of those submissions, in my respectful submission, are wrong, and they are wrong on high authority of this court and the House of Lords. Can I take them quickly? The point about proportionality being a hard-edged question of law, my Lord Carnwath said in argument with Ms Richards that of course the court knows that. It is not an error of law, or it is not a hard-edged question of law, it is a question of evaluative judgment. Can I give the court 3 references from the House of Lords and from this court to that effect? My learned friend referred to Wilson and First County Trust. It's paragraph 62, which is Lord Nichols, which is memory stick 775, where Lord Nichols expressly said that the proportionality assessment involves a value judgment by the court. Then there is Lord Bingham in Begum and Denby High School, and that's paragraph 30, memory stick 947, where Lord Bingham said the court must make a value judgment and evaluation. And then finally, my Lord Reed in Bank Malat at paragraph 71, and that's memory stick 1578, where again, my Lord said that it was a value judgment. And of course, that's unsurprising. As Ms Richards pointed out, it's a multifactorial assessment. Lots of different factors come into the account, and they can potentially pull in different ways. The judge assessing the proportionality.
As I said, Mr. Richards, we know that.
Yes.
Sorry, I don't want to.
Well,
You go on. You've given three great authorities to state the obvious, that proportionality
Well, my
is
Lord,
an assessment.
I take that point, but the starting point of Mr. Southey's argument was completely the contrary.
Yes, all right. Well, you disagree with him.
Well, it's not just that I disagree with it, it's just wrong in principle, my Lord. And that's where his analysis goes wrong from the very beginning, because these are not hard-edged questions of law which are susceptible to appeal in the way he says they are. There's the second point that he made about a domestic court being required to reach the same result as Strasbourg if matters went up that far. In this context, Mr. Southey relies upon the general aim of the Human Rights Act, familiar aim of bringing rights home. But it is simply not the case that one should confuse the functions of a domestic court, and in particular an appellate domestic court, with the functions of the court in Strasbourg. As Ms. Richards pointed out, essentially the court in Strasbourg deals with matters as a first instance court. It re-evaluates the facts and reaches its own decisions. It is not bound, obviously, by anything that happened in the domestic courts in the United Kingdom or anywhere else. And indeed, some cases go to Strasbourg without ever having been considered by the domestic courts. And Lord, the fact that that argument can't be made good is underlined by the case of RB Algeria, the decision of the House of Lords. And your lordships will find that in volume 3 of the authorities volume behind tab 23. It's memory sticks page 1092. And in that case, what was at issue was the scope of an appeal from the Special Immigrations Appeals Commission, and the statutory scheme provided that an appeal could only be brought to the Court of Appeal on a point of law. And the argument that was advanced in RB Algeria on behalf of the appellants was that it was a requirement of the convention that the Court of Appeal determine proportionality for itself, and therefore the Court of Appeal had to interpret the domestic statutory scheme allowing for a right of appeal in that way. That argument was roundly rejected by the House of Lords on the basis that neither the convention nor the Human Rights Act itself required that an appellate court undertake an assessment of proportionality for itself. And if I could just take your lordships to extracts from 4 of the judgments of their lordships in that case, starting at page 63, paragraph 63, which is Lord Phillips at memory stick 1192. And there we see a summary of the argument that was advanced, which is the one that I have just summarised. And Lord Phillips goes on at paragraph 64 to say, neither the Convention nor the 1998 Act requires the Court of Appeal to adopt the approach suggested. Lord Phillips then refers to Chahal and the United Kingdom and the discussion of Article 13 in that case. And he goes on to say the scrutiny that's required by the national authority does not even have to be done by a court, even less does it have to be subject to an appeal to a court. The United Kingdom has gone further than it has to under the Convention in giving a right of appeal. And in paragraph 66, he goes on to recognise the fact that Strasbourg may take a different decision if a case goes that far, but that in itself is not problematic, and that in itself is not something that results in either the Convention or the Human Rights Act requiring the domestic court to take a different approach. If I could go on then to Lord Hoffman.
Do they say anything different?
No, they don't say anything different, my Lord. It's essentially the same point, and it's rejecting the very point that Mr. Southey relied upon, which is that neither the Convention nor the Human Rights Act requires appellate courts to adopt any particular approach.
So it's not a point of law, but that doesn't help us with this case where the appeal is not limited.
Well, it does help you to the extent that it shows that one of the foundations for my learned friend submissions is
Yes.
wrong.
No, I understand you're knocking off his submission.
Yes.
At some point you want to get to the point which I suspect is certainly troubling me and maybe troubling my colleagues.
And that's Re B itself. So if I could come to that now, my Lord.
Well, what if the position was that this court concluded that Strasbourg would decide the issue in a particular way? Would it be obliged to make up its own mind, regardless of what it considered Strasbourg would do?
Well,
That's pretty
One might need to unpack that a little bit, my lord, and because that depends on all sorts of factors. That first of all depends on it being for this court itself to make up its own mind. Now, it might be a case where this court took the view that the way the decisions had been taken below were wrong as a matter of principle, but this court had the ability, it had all the information and material it needed to remake that decision in order to say...
There are plenty of pronouncements from this court to the effect that we should have regard to what Strasbourg would decide, aren't there?
Well, one obviously has to take into account what Strasbourg decided. That's what the Human Rights Act requires. I mean, that's a straightforward obligation.
No, that's the statutory requirement is to have regard to what Strasbourg has decided. But there are plenty of judicial pronouncements, recent judicial pronouncements, to the effect that we should take into account what Strasbourg might decide or would decide if we can reach a conclusion as to that.
Well, of course, the only way that this court can do that is by drawing on the previous authority and understanding that the way that Strasbourg approaches particular issues, that this court isn't engaged in...
I'm not sure that that's right, but no, leaving that aside, I mean, let's confront the question. If we were to conclude that Strasbourg would decide in a particular fashion, is it open to us to ignore that when we come to make the evaluative judgment that is required of us?
Well, my lord, with great respect, it might be that the way your lordship puts the question presupposes a conclusion that this court reaches on proportionality. So assuming for the time being...
I can't see how it does that.
Surely we need to look at a case where we've said that and see why we said it. Because, as you said, it's rather difficult to look at in the abstract.
Yes.
Anyway, you better get on with your argument because you've limited time.
Yes, my lord. So if I may come to Re B and just take a look at Re B in a little bit more detail, if I may, and your lordships will find that in volume 1 of the authorities bundle behind tab 6. And I was going to pick it up at paragraph 80 of Lord Neuberger's judgment, which is memory stick 568.
Yes?
And there Lord Neuberger notes the point that...
Sorry, paragraph?
Sorry, I beg your pardon.
My
It's
fault.
paragraph 80. It's at memory stick 568 behind tab 6.
You.
And Lord Neuberger introduces the issue by saying that ordinarily it's an evaluative exercise under the Care Act, but potentially the position is complicated by the fact that Article 8 is engaged. And he goes on to consider, and this is essentially the thrust of his judgment, is a consideration of whether or not the fact that Article 8 is in play makes any difference to the approach that the appellate court should adopt. That's the issue that Lord Neuberger is essentially dealing with. And paragraph 82, he goes on to state what his understanding of the general requirement of the Convention is. And then paragraph 83, he goes on to cite, by reference to Lord Wilson, the passage from Lord Hoffman in RB Algeria. Paragraph 84, it's the well-established understanding in relation to first instance decisions. He goes on to say that this doesn't mean that an appellate court entertaining a challenge to a judicial decision as opposed to an executive decision, of course a slight difference in the facts of Re B to this case, must similarly decide the issue of proportionality for itself. If it did, it would mean there were essentially two bites of the cherry. I don't consider that there's anything in the Strasbourg jurisprudence or in the 1998 Act which suggests that such an entitlement should exist. So very much echoing what was said by the House of Lords in RB Algeria. Then 85, he makes the point that what is required is that a court considers proportionality, not that every court up the chain of appeals considered it. And in paragraph 86, it must be a question of domestic law as to how challenges to proportionality are to be addressed. And 87, he goes on to point out the terms of the CPR. And then one comes to 88, which is where Lord Neuberger first sets out the approach that is to be adopted. And he looks at it from both sides of the coin, as it were, and it's on page 570, memory stick page 570. If, after reviewing the judge's judgment and any relevant evidence, the appellate court considers that the judge approached the question of proportionality correctly as a matter of law, so the court's properly directed itself, and reached a decision which he was entitled to reach, then the appellate court will not interfere. If, on the other hand, after such a review, the appellate court considers that the judge made a significant error of principle, so misdirected itself, and in using significant, I rather suspect that Lord Newberger was referring to a material error of principle rather than an egregious one. Any error of principle would do if it affected the outcome, or reached a conclusion he should not have reached, then and only then when the appellate court reconsidered the issue itself. So there he's very much talking in terms of an entitlement to reach the decision.
But I mean, are you saying, I mean, there seems to be a sort of undistributed middle, as they put it, because on the one hand he says was entitled to reach, which is one sort of way of approaching it. The other to say should not have reached, which is a slightly different approach.
Well,
are you saying we are to read should not, as though it said was not entitled?
Was not entitled
If it
to
means
reach.
that, then I understand what you're saying.
Yes. They've got to be two sides of the same coin, as they put it. One is the converse of the other. And Lord Newberger is very clearly talking in terms of being entitled to reach the conclusion that the Administrative Act was proportionate.
Yes, I wonder whether that's the approach we adopt outside the Human Rights Act field.
Well, it's certainly Lord Newberger's approach that he considers that the convention context doesand require the court to adopt any different approach
No,
from the way...
that's why I was trying to find out what that
That's what his
approach
judgment is predicated
Yes.
upon. And that's essentially what this comes down to. This has been rather dressed up as a great issue of human rights by Milford. It's not. This only becomes an issue of human rights if there's something in the Act or there's something in the Convention that requires a different approach. And Milford hasn't pointed to anything in either of those instruments that requires a different approach.
You see, when you get on to paragraph 93, he gets away from the concept of entitlement, and we're back on simply asking whether it's right or wrong.
Well, I'll come to paragraph 93 because that was very much a footnote to the main conclusion that Lord Newberger reached. If before I get to that, my Lord, if I may go on to paragraph 89, just to outline some of Lord Newberger's reasonings, because what he says is not only is this consistent with the normal practice of an appeal court in this jurisdiction, so precisely the point that my Lord Carmouth just asked about, what is the normal approach? Lord Newberger is saying, well, this is the normal approach. It's consistent with good sense, and this is where the point about oral evidence starts to come in. It's about the common sense of the approach. It's about appeal courts not being in as good a position to second guess, as it were, trial judges, where trial judges have heard oral evidence. So this is very much a supporting line of reasoning that Lord Newberger has, the pragmatic sense of his conclusion. And one will see from the very second sentence of paragraph 89, in many cases. So Lord Newberger is recognising that this won't apply in every case. And if one goes to the foot of that paragraph, he recognises that in certain cases his good pragmatic reason might not be as strong as in other cases. And then his second pragmatic reason is to do with costs, about the costs consequences that it would entail if at every stage one had to go through the proportionality exercise again and again and again. And then paragraph 90, he comes back to the fact that there are two strands in his reasoning. He says in the third and fourth line, it would be wrong in principle and potentially inconvenient. And he explains why it's wrong in principle, because the function of the Court of Appeal is simply to exercise a review of the trial judge's decision. And then he says it's potentially, not inevitably, but potentially unfair or inconvenient because of the point of appeal courts not seeing the witnesses. So that's where the point about oral evidence comes in. It comes in Lord Newberger's judgment as a supporting reason for his conclusion of principle. And then he goes on in paragraph 91 saying, well, what standard should be applied? The standard is...
Well, also,
Sorry, I beg your pardon.
well, I think it might be worth noting that what he is asking is what standard should be applied when determining whether the trial judge was entitled to reach his conclusion of proportionality. So that's the question that has to be answered. And that suggests that there may be no undistributed middle. The question is whether the trial judge was entitled to reach his conclusion.
Yes.
Either he was or he wasn't.
Yes. Your Lordship has come exactly to a point that I was going to come to, if I may say so. The difficulty in the analysis here seems to come in by way of paragraph 93, and perhaps the way that Lord Neuberger has expressed himself in paragraph 93, and in particular his category 4. It's perhaps slightly ironic, therefore, that Lord Neuberger prefaced that paragraph by speaking about the danger of over-analysis. Because my Lord Reed is right, there isn't an undistributed middle here. What one has to do is one has to ask, did the trial judge get it wrong? If he didn't get it wrong, then there's no room for the court to apply its own thought processes to the issue.
Yeah, but
if it did get it wrong, then the court can look at matters itself.
But by get it wrong, you mean, don't you?
Not entitled to reach.
Exactly.
Yes.
Error of approach.
Well,
Yeah.
one needs to be a little bit careful about error of approach more, because one can misdirect oneself in principle. One could say, well, the proportionality exercise is a Wednesbury exercise. I'm not taking the decision myself. I'm only asking myself the question, did the decision maker make a decision on proportionality which was within the bounds of reasonable decisions? That would be an error of principle. But there could be a second, one could call it an error of approach, where the first instance judge just went to such an extreme, as it were, in his judgment, that it was not a decision that it was entitled to reach. So, again, the two might shade into each other, but that's the approach. And one picks up, one gets Lord Neuberger's complicated, if I may say so, analysis of all the different options in paragraph 93. But again, one needs to recognise that's a footnote to his conclusions of principle that he's already reached. But then he comes back at the beginning of 94 to precisely the same point. And he says there's going to be a number of cases where an appellate court may think there is no right answer, in the sense that reasonable judges could differ in their opinion. So he's putting those into category 4. But in essence, what category 4 is that it falls within that category of cases where the appeal court can't say it was wrong, or doesn't say it was wrong. So really the danger that lurks in Re B, with great respect, is in paragraph 93. If one took paragraph 93 out of the analysis, it would all be very straightforward indeed, and it would simply reflect Lord Neuberger's very clear conclusions of principle that an appeal court normally only reviews, that's what the CPR says in relation to the Court of Appeal, it only looks at these matters of itself if the trial judge was wrong. Again, that's in the CPR. Is there anything in the Convention that requires a different approach? No. Is there anything in the Human Rights Act that requires a different approach? No. And that really is the end of the analysis. It's actually very straightforward. One just gets into difficulty if one, whether one overanalyzes, or however one puts it, paragraph 93. If one treats paragraph 93 as the tail that wags the dog.
Right.
So that's Re B. Well, the key paragraph is paragraph 94. Did the judge, the question the appeal court has to ask is, did the judge reach a conclusion that was reasonably open to him? Now, no doubt that the appellate court will adopt an anxious scrutiny type of approach to that. And indeed, anxious scrutiny is something that is referred to by Lord Neuberger in Re B in paragraph 94 itself. So the appeal court, the Court of Appeal, might have taken a different view, but under our domestic legal system, it's for the trial judge to make the primary decision. It's for the trial judge to do that evaluative, multifactorial, polycentric, however one describes it, decision as to proportionality. There may be greater or lesser leeway depending on the facts of the individual case. There may be factors that indicate that the judge had less room for manoeuvre or more room for manoeuvre. One of the factors that might indicate he had more room for manoeuvre, as recognised in Re B, is the fact that he may have heard oral evidence. And one needs to also bear in mind the type of oral evidence and why it assumes such importance in Re B. Because, of course, what the court in the Re B was doing was not just making findings of fact as to what had happened in the past. It was making a predictive judgment as to what would happen in the future. What would happen to the girl in question if the care order wasn't made? So oral evidence in that context becomes very important indeed. One has evidence from the parents, one has evidence from experts as well. all giving their insight. So again, one needs to be very careful not to take the references to oral evidence in Re B too far, because one has to, as always, to bear in mind the particular facts of that case. This approach is, I would respectfully submit, unsurprising and uncontroversial. As I said, there is nothing in the Convention, there is nothing in the Human Rights Act that requires a different approach to be adopted. Learned Friend has not pointed to anything in Article 8 or Article 6 that requires a different approach. The only article that might require a different approach could be Article 13, but Article 13 is not a Convention right. It's not a right that can be relied upon in the domestic courts. And it's not a right that is unlawful to contravene under Section 6 of the Human Rights Act. And again, if one goes to the discussion in RB Algeria, one sees that the House of Lords in that case recognised that it was the Human Rights Act in this country that implements Article 13. But we've heard nothing about Article 13, and there is nothing in the Article 13 jurisprudence, as Lord Phillips made clear in RB, which would require a different approach even if it applied. And for the court's note as well, one gets the same point from the decision in Re S in the House of Lords, which was a decision, or the judgment of Lord Nichols rather, memory stick 770, paragraphs 59 and paragraph 60 to 61. My Lord Colmouth asked me about whether there was another statement in the authorities that clearly set out what approach the courts adopt in the general context of evaluative judgments. Mr. Knight's done the best he can in the time available and has not been able to...
No, I mean, I think to some extent Lord Clarke's judgment sort of pulls
it all together, yes.
Hadmore, isn't it?
Well, it's had
more
more productions.
productions.
There's Pigloss, there's a number of them, but I mean, Lord
So I just
Clarke-
don't think we have any of those in
No,
there.
I'm sure they're fairly familiar. It's
Yes.
just what you do with them, which is a difficult.
Yes, and the court in Re B, well, that's one point the court in Re B was agreed upon. If one takes the human rights context out of the equation and one just looks at the route of appeal, the mechanism for appeal in relation to the making of a care order without the article
Yes, I mean,
context,
it's
it's all perfectly straightforward.
Thank you.
And one gets that from the passage that I cited in Lord Newburger's judgment. So, Lord, I think that's all I wish to say about the role of the appellate court. Just dealing very quickly then, bearing in mind the time, with the guidance. I would echo what Ms. Richards said about the guidance. It simply doesn't arise for consideration on the facts of this case. It wasn't in existence at the time of the decision. And in fact, when the guidance came into force, it dealt with a slightly different statutory scheme, because the scheme had been amended by the time the guidance came in, to that was considered by the Chief Constable in this case. So I would urge, again with respect, the court to be cautious about embarking on an exercise of construing the guidance, given it cannot affect the outcome in this case. But in relation to the guidance itself, your Lordships will be alive to the fact that the guidance seeks faithfully to replicate the approach that was laid down by this court in L. There are very strong echoes of Lord Newburger's judgment in L and the factors that he identified throughout the guidance. And Ms. Richards took you to a passage from Lord Hope's judgment in Real, dealing with the relevance limb of the test, the limb of the test that's not before the court, or there's been no allegation that the Chief Constable didn't apply it properly. And in that extract, it was paragraph 39 of L, memory stick 526, Lord Hope said that in forming an opinion on relevance, the police must ask if the information might be true. So Lord Hope clearly envisaged an exercise of the police looking at the information and at least reaching some sort of view on its veracity in the relevance context. And Lord, as again Ms. Richards pointed out, the passage that my learned friend relies upon falls within the section of the guidance that deals with relevancy. It doesn't fall within the section of the guidance that deals with proportionality. Your Lordships will find the guidance at memory stick page 2038. It's Authorities Volume 5 behind tab 53. And if I could just take your Lordships briefly to the relevant paragraphs, if I may, starting at page 2040. And there we see the main heading, principles to be applied in paragraph 10 in deciding what, if any, information should be provided for inclusion in an ECRC, and in providing that information, chief officers should apply the following principles. Then various principles are set out with subheadings underneath each principle. And one sees after paragraph 11, principle 2 is dealing with the relevancy issue, so the first limb of the test. And then at the end of paragraph 13, we can see the guidance that's given. The most important factors which should be taken into account when considering relevancy are as follows. However, this is not an exhaustive list, and other factors may come into play in individual cases. So it's setting out a non-exhaustive list of factors relevant to relevancy, if I can put it in that way. And then one goes over the page to paragraph 18, and one of the factors that would be taken into account is that the information should be sufficiently credible. And say this will always be a matter of judgment, but the starting point is to consider whether or not the information is from a credible source. So completely uncontroversial. It's for the police to form a judgment on the facts of the particular case, deciding whether or not the source of the allegation information is credible. No threshold applied there. Chief officers should consider whether there are any specific circumstances that lead them to consider that information is unlikely to be true, or whether the information is so without substance that it is unlikely to be true. All that is doing is telling the police that they shouldn't take information at face value. They should look at all the circumstances. Is there anything that casts doubt on the information that is proposed to be disclosed? And in particular, allegations should not be included without taking reasonable steps to ascertain whether the allegations are more likely than not to be true. In essence, it's not imposing a duty on the police, but it's suggesting to the police that as an investigatory function.
Well, I understand that, but what if I am the inspector? Am I supposed to make of that last sentence?
Well, what it's intended to convey to the police is that the police should not just simply take something at face value, but they should take steps to decide or to reach a view as to whether or not there is truth in the allegations.
But it must presumably mean, must it? In particular, allegations should not be included without taking reasonable steps to ascertain whether they are more likely than not to be true, but may be included even if they are not.
Well, one needs to be a little bit careful about saying even if they are not true.
No, even if they are not more likely than not to be true.
Yes. Yes, well, that goes back. One has to read the paragraph as a whole, and one has to read it in the context of the first sentence, that it's always a matter of judgment, and the starting point.
You may well be right, that's what it means.
Yes.
It's have a good look.
Yes, don't take the guidance is very conscious, as has been repeated in submissions throughout the day before the court, that these are serious matters that require careful consideration. And this is emphasising to the police that they shouldn't simply take allegations at face value and put them in a certificate.
The other thing that occurs to me, I've only read it rather briefly, and if I've missed it, tell me, but is there anything in the guidance about the particular case of people who've been acquitted?
No, I don't.
I thought not, and that's presumably deliberate. But they must give rise to particular considerations.
Well, I wouldn't be able to say whether or not a deliberate decision was taken not to include something, because, of course, there are all sorts of types of cases which might give rise to difficult considerations in this context. And
surely
this has to be a workable guide that can be applied to a range of
circumstances. And all acquittals are not the same, because sometimes the trial will have demonstrated the truth one way or the other, and sometimes it won't.
Yes. And one has to be fair, this is fairly short guidance. This is not an exhaustive decision-making document. It only runs to six pages. But this paragraph, and one, again, has to bear in mind the context of this paragraph. This is talking about the relevancy limb, where it is accepted all round that the threshold for meeting that limb is relatively low. And that was what Lord Newberger said in L, and it's been accepted on all sides, and there's never been any challenge to the relevancy criteria being met in this particular case. So one needs to be careful, in my respectful submission, about reading too much into paragraph 18. No doubt it could be better worded, but then there's very rarely one finds guidance that couldn't be better worded when put to the forensic scrutiny of a particular case. The final important point about the guidance, if I can conclude on this, is, of course, paragraph 22 is the paragraph that deals with proportionality. One sees principle 3 as the ought to be included, and then one gets the factors there. And of course, what it says about proportionality is the second sentence in paragraph 22. If disclosure is considered necessary to pursue the relevant aim, then the question becomes one of proportionality. In practice, this will involve weighing factors underpinning relevancy, such as seriousness, currency, and credibility against potential interference with privacy. So certainly not saying there's a balance of probabilities threshold, and even more so, not saying that that balance of probabilities test is some sort of gateway or threshold test that has to be satisfied before anything can ever be disclosed, which was...
Not really privacy, is it? It's employability.
Well,
Yes, of course, the potential employer has to hear, but as we've been told, he or she can't pass it on.
Yes, I rather suspect is shorthand to the right to respect for a private life.
Yes.
I imagine so, yes.
Yeah.
And indeed, if one sees paragraph 20, my lord, one sees that the fuller text of Article 8 is set out, so one has to read it as following on from that. It's simply shorthand for that. Lords, unless there's anything else I can assist you with, those are the Secretary of State submissions.
Thank you very much. Mr. Knight. Oh, you would if I told you to, but never mind. Mr. Sayyid.
Thank you, my lords. Can I deal with things slightly out of order and deal firstly with the point about the role of an appellate court? My learned friends, both of them, I think, emphasised that, to use their language and to use the language of this court, that proportionality is a value judgment. That's true, but in one sense it doesn't really help one very much because there are value judgments and value judgments. In some circumstances, where one looks at, for example, a true discretionary power, value judgments involve reaching conclusions within a range of possible conclusions. In this context, the context is different. One has to look at why the value judgment is being reached. And the reason the value judgment is being reached is because Section 6 of the Human Rights Act makes it unlawful to act in violation of the Convention. And so if the value judgment is reached, if the conclusion reached at the end of that process is a wrong one, it's unlawful. And that's what Strasbourg ultimately is seeking to do. I didn't give the reference to it earlier. It's Huang, I won't take the court to it, Huang, Volume 2, Tab 19, Paragraph 18, about how Strasbourg seeks to draw a line, essentially, between what's unlawful and what's lawful. And that's what the domestic courts need to do. And I'll come back to that. And that's essentially the critical point here, is that the first instance judge's task, although involving evaluating various sort of factors, is ultimately to determine whether or not there was illegality in Section 6 terms. And that's the flaw in, I think, my learned friend Mr. Moffat's submissions. He says essentially it's no different to other cases where there's an evaluation. But that's not correct, because in this case, the evaluation is ultimately trying to determine directly whether there's illegality or not. And that explains the approach of Lord Neuberger. Can I take the court to Lord Neuberger?
Lots of evaluative judgments
Sorry?
go to lawfulness.
There are quite a lot of types of evaluative judgment where the evaluation leads to a conclusion about lawfulness.
I'm not saying this is unique in that context, but I'm saying it's not. There are, to use my language, there are value judgments and value judgments, and one needs to look at why one is reaching that value judgment, what the nature of the task one is seeking to undertake, and that does reflect in my submission the approach of Lord Neuberger. Can I just draw attention to a number of passages in it to make good my point?
Which one are we looking at?
Read B, I'm afraid, again, which is tab 6.
Sorry, I must shut up now.
My Lord Reid put to my learned friend essentially that the question, the question Lord Neuberger was setting himself essentially in paragraph 91 was the key question, and it started at the start of paragraph 91 with the language whether or not it referred to the trial judge being entitled to reach a conclusion. But of course, the question that was being asked was essentially what was the standard that the appellate court should apply in that context. Now, in that context, that passage rather is immediately followed by the first reference to wrong, and the fact that it's then said that the issue isn't whether or not the judge was plainly wrong. But it's important to go back to the point I was about to try and address, which is the significance of value judgment. Lord Neuberger, in paragraph 92, was quite clear in my submission that particular issues arise where convention questions are in play. If one goes to letter C, paragraph 92, it's quite clear that he's limiting his comments to the issue of convention questions such as proportionality. First there, at least where convention questions such as proportionality are being considered, I consider the reviewing trial judge that if after reviewing the trial judge's decision, an appeal court considers he was wrong, the appeal should be allowed. So he's linking that test of wrong, or that question of whether the decision was wrong, to the particular issues that arise in this context in my submission. And it's not some sort of general application of the approach to evaluative judgments.
I'm sorry, but as I read it, as I was put to you for your comments, he's up until paragraph 91, he's been saying that the critical issue is, was the judge entitled to reach the conclusion that he did on proportionality? And he then addresses the a rather arcane debate about whether that question of entitlement to, whether the appeal court's determination of whether the trial judge was entitled to reach the conclusion he did depends on whether they think the trial judge was wrong or was plainly wrong. And plainly wrong, as the way he puts it in further on in 91, either plainly adds nothing, or it means that the appeal court can't interfere if it thinks the judge was merely wrong. That's the point he's trying to focus on there. Just how wrong is how wrong does the first instance judge have to have gone before you can say that he wasn't entitled to reach the conclusion that he did?
Well, I'd accept that the question that's being asked, in one sense, to use different language, but I think it's consistent with what my Lord is saying, because it goes back to the question Lord Neuberger was setting himself in paragraph 91, is what standard should be applied when determining whether or not the judge is wrong.
The whole reason why he's getting into this topic is because he had Lord Fraser in G&G, which was about essentially the same issue, where the expression plainly wrong had been used, which had overtones of, if you like, manifest unreasonableness or something of that kind. And this court was drawing back from that and saying it isn't as if the trial judge has to have done something that suggests he'd lost his senses.
But in my submission, it goes slightly beyond that, in the sense that there was also, one has to take account of the point I made this morning, which was that there was obviously a debate among the members of the court as to whether or not the court should directly, on an appeal, assess proportionality. And Lord Kerr and Baroness Hale were in the minority. And what one sees in paragraph 92, 93, 94 and 95 is not merely a sort of a departure from Lord Fraser's judgment, but in my submission also a consideration of whether or not the court should go as far, essentially, as Lord Kerr and Baroness Hale. And one ends up at paragraph 95 with a paragraph effectively saying, I'm not going that far, to paraphrase, but there's not much difference between the approach I'm adopting and the approach of Lord Kerr. And the reason, in part, for that is that, in particular, as one gets into the issue of proportionality, the value, essentially, of oral evidence becomes less. And so the room for a case to fall within Category 4 becomes narrower. And the implication of that has to be that when one gets to a situation where there's no oral evidence, where it's the material before the appellate court is the same, Category 4 becomes non-existent. In any event, whether I'm right or wrong about that, given that Lord Neuberger is very clear that the grounds upon which an appeal will be allowed are not merely that the findings were unsupportable. On any version, Lord Neuberger must be going beyond simply saying this is how this is a sort of traditional appellate review function. And that's one passage that the court hasn't seen that I probably should have drawn attention to in opening is Lord Clark, who was in the majority, and it's at paragraph 140. And Lord Clark also gives an account of what he thinks is meant by wrong. And he makes it clear it's not the sort of traditional no reasonable judge conclusion. So, my Lords, we do submit that when read properly, one sees in paragraph 92 a recognition that proportionality is different. In our submission, unsurprisingly, given the nature, given the origin, rather, of judicial review challenges relying on the Convention. And what one then sees is this attempt to sort of categorise cases where there is a tension, essentially, between the problems faced by an appellate court not being able to assess afresh all the oral evidence that's been heard, but the need also to ensure that proportionality is properly assessed. And the approach of Lord Neuberger is to recognise that there are, where oral evidence is given, this category of cases where one can't say whether or not the judge was right or wrong, but to recognise that as oral evidence becomes less important, that category reduces. Can I just say one other point about, make one other point about B? My learned friend placed a significant amount of weight on the approach of the Court of Appeal in RB Algeria. RB Algeria was about whether there was a right to appeal. That is clearly what was understood by Lord Neuberger at paragraph 83, because he deals essentially with what I understand to be a reference to Lord Hoffman's judgment in RB Algeria. But it doesn't prevent him then going on to look at what he'd regard, what in my submission is quite clearly a separate issue, and what Lord Neuberger seems to regard as a separate issue, which is what is the scope of an appeal when there is an appeal domestically. And obviously in that context, we would refer to, my learned friend says, the role of the domestic court is not to try and effectively get the same conclusion as the European Court of Human Rights, but if a reference is needed to contradict that, it's the well-known dicta of Lord Brown in Rabone, where Lord Brown in Rabone talks about the need to try and predict what the European Court would do. And the reference to that is volume 4, tab 31, paragraph 112, memory stick, page 1509. Can I move on then to, from the role of the appellate court to the sort of the underlying issues, whatever the role of this court is? My learned friend, Miss Richards, I think it was, started by making reference to the statutory scheme and referred, for example, to Lord Neuberger's judgment in L about how the scheme, on the face of it, potentially extends to matters such as mere suspicions. Quite clearly in that context, Lord Neuberger was referring to the fact that the statute requires first an assessment of relevance, and in that context it is a relatively low threshold. But it doesn't say anything about what then follows, which is proportionality. And Lord Neuberger's judgment in paragraph 81 indicated, as my learned friend pointed out, that one of the factors that is relevant is reliability. And that's where the issue of whether or not this is more likely than not to have occurred, or whether the allegation is more likely than not to have occurred, fits in. My learned friend says, essentially, it's not for any decision maker, the court or the police, to decide whether an allegation is true or false. Now, in the classic sense that we're all very familiar with in civil trials, where one has this slight fiction that if one could prove to a 51% chance that something occurred, then one works on the basis that it actually did occur. Of course, that's right. One's not concerned here with sort of saying, well, this is 51% likely to have occurred, and so we'll all proceed on the basis it occurred. But what is quite clear is that one has to work out where on a spectrum something falls. At one end of the spectrum, there is something that's 99% likely to have occurred. At the other end of the spectrum, there's something that's 1% likely to have occurred. And that's got to, in our submission, highly relevant to proportionality, because if something's only 1% likely to have occurred, it's particularly draconian to then disclose it, because there's a 99% chance, effectively, that the person will be tarred with an allegation that they're not guilty of. And that is why, in our submission, it's not surprising that on the decision-making in this, on the paperwork in this case, it's quite clear that there was an attempt to work out where on that spectrum the issue fell. The problem in this case is that obviously the findings of the High Court judge indicate that those findings were flawed, and that's quite significant because it suggests that the justification relied on by the police was a flawed justification. Now, my learned friend says, well, one wouldn't want the balance of probabilities test essentially to feed into the certificate. But we're not arguing about that. What we're arguing is about the decision-making process and the fact the decision-maker, when assessing proportionality, needs to assess how reliable this is. And that's where...
Does that mean that the decision-maker has to address the question whether, on the balance of probabilities, the allegations were true?
Well, the decision-maker, fundamentally, if one ignores the guidance for the moment, I'll come on to the guidance in a moment. If one ignored the guidance, the primary issue the decision-maker has to assess, because of proportionality, is where on the spectrum, as I say, between 1% and 99%, the case fits. Now, having said that, sort of human instinct is such that if it's, in fact, below the 50% prospect, it does seem, on the face of it, a more radical step to disclose, because what one's doing then is disclosing an allegation that will have serious consequences for the individual in circumstances where they are probably not guilty of that allegation.
What if a decision-maker said to herself or himself, well, I'm not going to address this on the question of probabilities. I'm not going to reach a decision on the onus of proof, but I'm simply going to ask myself where it comes in the spectrum of possibility, and it comes somewhere round about the middle. I'm not going to specify where in the spectrum it comes, but it's between 30 and 60%, and therefore I think that other things being equal, the certificate ought to be issued. Is there anything wrong with that process?
Well, depends upon, my answer to that was it would depend upon what the rest of the reasoning was, in the sense that if one's saying, I can't really work this, where this, I can't work out precisely where on the spectrum this fits, but it might be 30%, it might be 60%, one has to recognise that in fact it might be at the 30% end, and one has to recognise that then a more powerful justification is required. So, and that's where the guidance also would potentially come into play, because the guidance is obviously based on sort of an assessment of what is necessary. My learned friends say it's all about relevance, but if it's not relevant, and if it's not relevant, if it doesn't cross the, then it's a bit difficult to see how it could be proportionate to disclose. And indeed, the passages that my learned friend Mr. Moffat took the court to indicate a recognition in the guidance that there's a relationship between relevance and proportionality, unsurprisingly. But what in my submission that guidance recognises is that there is just, consistent with what I said a moment ago, that there is something instinctively objectionable rather, about disclosing something when it is less than 50% likely to have been true. My learned friend, Mr. Moffat, focused on the third and final sentence in that guidance, but one needs to remember the second sentence, and the second sentence expressly requires the decision. It's volume 5, if anyone wants to look it up. It's volume 5, tab 53, memory stick, page 2041. But the second sentence expressly requires a consideration to be given as to whether something is unlikely to be true. Now, it doesn't say, and there would be problems if it did, not least because it's only guidance and it can't modify the statute. It doesn't say one can never disclose when it's unlikely to be true, but it does suggest that that's a very significant factor, unsurprisingly, for the reasons I indicated. And so going back to my Lord Kerr's question to me, as I say, I've never argued that if it's less than, there could never be a circumstance where something's only 30% true. There could never be a circumstance where one discloses that sort of allegation. However, one needs to recognise that it's a pretty draconian step, and there would have to be some particularly good justification for doing that. And that's why the guidance in my submission draws attention to whether or not something is likely to be true or not.
Yes.
A couple of other factors relevant to proportionality that I just draw attention to. My learned friend, Ms. Richards, disputed whether or not an acquittal was relevant because of the risk of stigmatising. Can I just give the court reference to a passage we would rely on in a judgment of the European Court of Human Rights? It's the judgment in S and Marper, the DNA case. It's paragraph 122. Don't have the memory stick page because I just noted it down in passing, but I may be able to find that in a moment. It's volume 5, tab 50, which makes the point that stigmatising somebody who is entitled essentially to the presumption of innocence, even in cases where the presumption of innocence doesn't apply, is problematic. The judgment, I think, starts at memory stick page. I'll find the reference.
It's paragraph 122, did you say?
Yes, it's paragraph 2, it's page 2001.
Thank you very much.
Thirdly, in considering proportionality, I'm going to address procedure in a moment, but one does need to take account of the procedural issues that arise in this case, because it does mean, which was recognised to some extent by His Honour Judge Rayner, that the police had more limited information than perhaps they ideally would have had, and I'll come back to that in a moment. But I then turn to some of the submissions about the facts. My learned friend sought to minimise the significance of starting from the CPS test and saying it indicated that the allegation was more likely than not to be true. I don't think in the end there was any dispute that was not a reflection of the CPS test, which is looking at whether or not the jury is more likely than not to convict. And that matters for, I mean, that's a sort of paraphrase, but it's focused. The reason I was going to say that matters is because, of course, by the time the police are considering the matter, in one sense, things have moved on very dramatically. The police are trying to predict the outcome of the jury, but by the time, it's not the police, the CPS are trying to predict the outcome of the jury, but by the time the police are taking a decision, everyone knows what the jury's outcome is. The jury have decided to acquit. And so the CPS decision has been overtaken by events because it is focused essentially on predicting what the jury outcome will be. And that's why, in some senses, the misstatement of what the test matters, the misstatement of the test matters. Turning then to the final reasoning, my learned friend placed a lot of weight on the fact, as well as saying this allegation is more likely than not to be true, the police indicated in alternative reasoning that it might be true. But when one reads that reasoning as a whole, the police appear to be saying both are met. Both this is a case which might be true, and it's more likely to be true than false. And that's important because that goes right to the heart of the justification for disclosure. If you believe something is more likely than not to be true, it provides an important pointer to disclosure potentially. If you get that wrong, it means that the weight to be attached to your decision has to be reduced because one's relied on a justification that in fact isn't present. To procedure, my learned friend started by saying it's impossible to be prescriptive about the procedure, and I accept Strasbourg hasn't ever sort of said one has to do X, Y, Z in quite those terms. But my learned friend indicated that she accepts that the issue is whether there was sufficient involvement in the decision-making process. I hope I've noted her words correctly. An involvement in the decision-making process can only occur essentially before the decision is taken. And that's consistent with the language in L. Lord Hope, I'll give the court reference, it's memory stick page 528, paragraph 46. It's quite clear that the involvement needs to be before the decision was taken. Now, the involvement in this case, before the decision, was essentially the involvement in the trial process. My learned friend, I think in question, in response to a question, indicated that her case was that the primary opportunity to rebut the allegations is the criminal process. But that implies that if one has successfully rebutted the allegations to the extent one can in the criminal process, which is to obtain a not guilty verdict, the reasons for that, to the extent they can, need to be investigated. My learned friend made reference to the RK judgment, and I'll give the court the reference to it again. It's volume 4, tab 34, memory stick page 1568, paragraph 57. The judge at first instance in that case was very clear that if one's going to go effectively behind an acquittal, it's very important that one has full details of the evidence. One has transcripts, one has possibly a report from counsel. And in that context, my learned friend says, well, the appellant hasn't sort of identified what might have been in those transcripts. The appellant, of course, has been, the appellant has until very recently not enjoyed the benefit of legal aid. He is self-funding. He was self-funding rather up until a very recent stage. It's for the state, essentially, if it's going to interfere with Article 8 grounds, to justify that interference. The state has those resources. Now, my learned friend says, well, essentially, we can't demonstrate that there was a breach of the Thameside duty in terms of the failure to get the transcript. But, of course, there's two things I would say in response to that. We are in the context of Article 8, and so the primary issue is whether it was proportionate to disclose in circumstances where there was the degree of uncertainty there was about what happened at trial. And, of course, Thameside, in our submission, when using the language of unreasonableness, needs to be read with the approach of this court in cases like FAM, that reasonableness needs to take account of what's in issue. And here, there was a potentially draconian step. It was a very serious step that had potentially career-threatening consequences for the appellant. And it was important to know why the trial had resulted in the outcome.
Well, do you accept the point made that it's necessary for you to set out what representations would have been made and whether those would have made a difference?
Well, except it comes back to the point I made to my Lord Hughes this morning, that the primary point we make in relation to that, and we've always made, is that the problem with this is that there was no procedure effectively to involve the appellant before the decision was taken. Because what happened in this case was, as my learned friend set out, the first disclosure occurred. He wasn't involved in that decision. That was reviewed by Miss Wilson, who was, you heard, the decision maker for the IGU. She then becomes the decision maker essentially for the second decision, and her decision making is almost word for word, certainly very similar. She basically takes the language from the first decision and feeds it into the second decision. So there's no opportunity essentially for the appellant to make representations where the decision maker was open-minded, and that's the real issue in this.
Yes, but if we're addressing the question of procedural impropriety, is it not relevant for us to consider whether or not there were representations that might have been made which might have influenced the decision maker?
Well, my lord, the answer to that, as I say, is that if the complaint is the representation should have been considered at a time where the decision maker was open-minded, then the representations that were actually submitted, and there were representations that were submitted, are ones that we can rely on because they've never been considered properly by a decision maker who was open-minded. That's the problem. That's the primary issue point we make. Finally, I should, in that context, touch upon the review mechanism. Obviously, as both sides are agreed, there was no review mechanism at the time. All I would say in relation to that is two things. Firstly, the extent to which the review mechanism is necessarily compliant with Article 8 isn't obviously an issue, but there is an issue about the fact that decision-making process occurs after the decision. It occurs after the the certificate has been provided. And the Article 8 process, perhaps for understandable reasons, is about involvement before the decision. That's not obviously an issue for today, but it's just a marker that perhaps I ought to lay down. Secondly, more importantly, in some senses, the issue of the monitor demonstrates why, in some senses, the procedural issues were so important in this case. The fact there wasn't a monitor in circumstances where Europe, for example, has indicated the importance of independent review in relation to disclosure, meant that it was particularly important that the procedure was fair and that it properly represented the importance of the issues at stake. The absence of a monitor in some senses demonstrates why it was important the police were fully informed, essentially. Well, I think that probably covers everything I need to cover.
Good. Well, we're very grateful to Council for the submissions and to those who framed the skillful written arguments. We'll take time to consider our judgment. The court is now adjourned.